So I want to welcome everybody tonight. Welcome to an April Salt Talks. We are getting close to the end of April, hard to believe. This whole month we're looking at future preparing, planning, and saving. What do you do? How do you prepare for all this? Um, Last week we talked about Social Security. We touched on it once again. And next week we're going to be talking about stable account. But tonight we are working on learning about the Special Needs Trust. How does the Special Needs Trust how does that come into play with our plans, future plans? What do we do as parents? What do we do now? And how does that look for the future for our individuals with disabilities? It's a lot of pre-planning to do. There's a lot of things to think about. Not only the here and now, where you've come from, you have the here and now, but then you have the future, you have beyond, even when you're no longer here. How do you plan for that piece when you're not here to take care of your child? So we're trying to hit on these topics just to help you out. And get an idea of some direction, some guidance, and where to go. So tonight I have Laura Drake. She's an attorney at law with Drake Law. She's going to be talking to us about the Special Needs Trust. Um, and she is a world of knowledge. So there is no question that you can't ask this Laura here. That
Except don't ask me how much money you need to leave for your child. I don't know. I get that. That's the one question I get that I'm like, I don't know. I don't know what they need. So
So I'm going to turn it over to Laura. And Laura, I gave you sharing abilities so you can share your screen. And go ahead and introduce yourself.
hi everybody. My name is Laura Drake and I'm an attorney and I cannot find my thing. I hate computers. I work with families who have children with special needs, and that's a lot of what I do. And I also work for Pro Seniors, which is an organization which helps people over the age of 60 and who have legal issues. And I teach at Ohio University. So I just like to keep busy. And it's kind of how I look at it. So, so uh, I oftentimes give talks about estate planning, and especially for families with special needs, and alternatives to guardianship is another thing I talk about a lot. Um, and so what we're going to do tonight is kind of have an overview of estate planning, and then specifically how we address that with a family when we have a family member who has special needs. So let me. Oh, there it is. I'm like, I know I have this thing here. All right, so I'm on the last page for some reason instead of the first page of the PowerPoint. But other than that, we're going to do this. So let's see. So slideshow from the beginning. All right, so I can't actually see everyone. I can't see the chat anymore. But Patty, if you have a question, please feel free to ask it. And if it's urgent, tell Patty to interrupt me. And if she thinks it makes sense, will also interrupt me.
I'll keep an
So
eye for you. I'll keep an
yeah,
eye.
exactly. She'll watch that for me. So, just so we know, this is just educational purposes. Your situation should be different. Nothing that we're saying here should be used as a definitive answer for your situation. I want to make sure you understand that. But this is general information about what people should take into consideration mainly. So, we're going to talk about how to set money aside, right, to provide for your children. And mainly that's for after your kids are gone. There are ways of providing money for your children now if they need it, and that's mainly the stable account, and you're going to get another presentation about that. So I will talk about stable, but it's just a small part of this. So but the big thing is you want to provide for your child who probably receives Medicaid, and there are lots of ways to do that. That is not hard at all. We can do that. So there's most of us are providing for many people are providing for their children, and they're not receiving government benefits. There are different types of government benefits. So ones that are not means tested, which means anyone can get them regardless of how much money they have, is Social Security Disability, SSDI. So if you and I have a job and we're out working and we're paying into Social Security, and then we have an accident, it doesn't have to be a work-related accident. It can be a car accident, over the weekend. It just doesn't matter. And I can't work anymore. I'm entitled to SSDI. And SSDI doesn't matter that I have $1 million in my IRA and a $700,000 house, and it doesn't matter that I have $1 million sitting in my brokerage account, which, by the way, I would like all of those things. So if you can take care of that, that'd be great. I'll take the $2 million and the $700,000 house, but whatever. I can have all those things and get Social Security disability insurance. Why? Because it's supposed to provide my monthly income so I can survive. That's the whole point. Basically, I probably can't work again, or I'm not going to be able to work for a very long period of time. And so the government is going to help provide for that. And because I paid into the Social Security plan, I get some of that money back. It's kind of a form of insurance. If I'm on Social Security disability, after 2 years, I'm eligible for Medicare as my health insurance. I know we always think we get it when we're 65, but if I'm on SSDI, I also get Medicare. And Medicare doesn't care how much money you have. All right. So now if I start working again and making some sort of income, I'm probably going to lose my SSDI. But usually no one cares because, they're making money again. And then with that, I would probably also lose my Medicare. What we're usually concerned about is Medicaid. So Medicaid is generally, there are different types of Medicaid, but we're not going to go through all of them. Generally, I can't have more than $2,000 in my bank account and be eligible for Medicaid. And there's so many types of Medicaid, but mainly what we're talking about is health insurance. And most of us don't care so much anymore until our children are over 26. But we're also talking about waivers. We're going to talk about waivers a little bit more, but these waivers that provide care for my child, not just health insurance. The other means-tested government benefit that we care about is SSI. So that's supplemental security income, and that's for the age, blind, or disabled. And I fixed it later on. It's not 841, it's 9 something. I didn't realize I didn't fix this page. I swear. Anyway, I thought I fixed that. So it's $940. And something about that. But anyway, so it's closer to 1,000 now. So that is basically supposed to provide for housing, food, and clothing for individuals. Nobody could survive on that. That's crazy, but that's the plan behind it, right? Now, these income can affect both these benefits. However, there is a goal in the system that we want people who are on SSI to be working, so they can actually earn up to the amount of their SSI before they start to lose it after 10 months. And even then, it's for every $2 they earn, they lose $1 of SSI. So they're still better off to be working even part-time. When we have money like this, the big thing is we don't want to try and hide it. And families get in trouble for this all the time, where they, especially they were getting money, they had money in a child's account, and then they basically transfer it to mom and dad's account, or they put it under the mattress or in a shoebox. You have to be very careful, because that is technically, it's fraud. It appears to be fraud. And so if we have too much money, there are lots of ways now to transfer that. So if grandma left your child $10,000, which seemed like such a nice thing, and now it's becoming a problem because they're 18 and they can't get on SSI. Except, even though it's not very much fun, you could spend that money to prepay for burial. You can spend it on any of their needs. You just can't give it to somebody else. That's inappropriate. But the big thing now is we have stable accounts, so there's some really easy ways to take care of that. The reason when we're looking about Medicaid, to get Medicaid, and we're usually concerned about the waiver more so than health insurance. We're looking at, are these assets accessible? Can I get them? So again, grandma left $10,000. That becomes accessible once the estate is going to write the check. If I'm working at Kroger and I'm paying into the pension, or I have an IRA at any job that I have, and I'm giving that money over, as long as I'm working and I'm putting money into the company 401k, that money is not accessible. I could borrow against it, but that's not what we're looking at. As an employee, you can't actually wipe out your 401k. it becomes accessible when I quit that job or I retire early because I can't do the work anymore. And when that happens, suddenly that IRA becomes accessible. There's some new rules with that, but still the 401k becomes accessible, and that can create a problem. All right, so we're looking. This is what happens when this is when we have a problem. We're on Medicaid, and suddenly we come into some money that might make our eligibility questionable. And then, and if you leave your money to your children outright, you will make them ineligible, right? Because you're probably going to leave them more than $2,000. So your obligation to provide for your child actually ends when they turn 18. You're not going to do that because you're not going to do that. But if you want to, you can provide for them long after. So I have an aunt, and she suffered an injury, an illness actually, when she was about 11 months old, and that caused permanent brain damage for her. And my grandparents died in 1972. They were very young. They were only in their early 50s, and my aunt was not 30, or she was just 30. And so back then, the only option they had for her was to disinherit her. And so half their estate went to my mother, she hates when I tell this story because I'm very specific. She was 32 when her dad died. And half went to my uncle, and he was 19 when his parents died. And they didn't actually die together; they died a few months apart. But so he was 19 when my grandfather died, and my mom was 30. My aunt, you guys can know how this probably didn't end well, right? The idea was that they each inherited 50%, but they were supposed to, in their minds, earmark, a third of the total funds for their sister. And to this day, till the day she passed away, my mom felt that they had not spent the third on my aunt, on her sister, and my uncle felt they had many years before. So that's all the option was in 1972. By the 80s, people put what are called spendthrift trusts, but now we have amazing state-sanctioned and federal-sanctioned options, specifically trusts, where you can leave money for your child. It does not impact their benefits at all. They get all the benefit of the money, and what's really great is your other children or grandchildren get the benefit of any money that the child doesn't use afterwards. And so you don't have to disinherit. And there are still attorneys out there who will tell you to disinherit your child with special needs. And let me tell you, don't use them. I would not recommend using them. I don't think that there's someone who is very empathetic to the situation. And I don't think they realize that Medicaid, though it does provide a lot, it cannot cover everything. It will not cover, it won't cover dental. My aunt, she had a phobia about people touching her mouth. And so dental work was a huge nightmare. We're from Iowa. We love our corn on the cob. At the end of her life, she had one tooth remaining, and she could still take an entire corn of cob and eat a corn of cob with her one tooth. But my mom always said it's her greatest regret that she didn't start providing more money for her to have root canals when she was much younger. They couldn't put like a plate or anything in there, or false teeth, and that she wouldn't use it. So the only thing they could have done to save her teeth was root canals, and they didn't do it because it was so cost prohibitive early on. And by the time they realized what they'd done, it was really too late. So, so having that money for those kinds of options is really important. All right, the other thing, when you're doing a trust, which is how you're going to provide money for your children long term, you need to have a will. And under Ohio law, you want to make sure that you list all the people who you want to be guardians of your child in the will. And you want as many people as you can. It says here, at least 3 if you can. I have done documents where I have named 30 people as potential guardians. Why not? Who cares? They're listed. And if the rules are that people in the state of Ohio have preference over people out of the state. And so if you have if one of your kids has moved to Indiana or Kentucky or, those are the states, Pennsylvania, then, you very easily might want that child who's not in the state to be the guardian over somebody who is in the state. And so by listing who you want, you have power over that, and you can list all those potential people to be guardians. Even if you decide you don't need to get guardianship, you still can point out in your will who you potentially want to be your guardians. We still recommend that because situations change. If you're going to disinherit your child, you should say that in the will. But generally, like I said, I recommend usually equal shares. You have to be careful when you're adding, in my opinion, you have to be careful when you decide to lead an extra share to the child with a disability. And obviously, it depends on your situation. If you're going to do that, you need to have that conversation with the kids earlier on, because there can be some animosity that gets started up with those kinds of things. So the other thing is, some people say, I can't afford to do a special needs trust now. I can't do all that planning. You can give your executor the authority to create a wholly discretionary special needs trust after you pass away. We see those in Ohio, especially in Hamilton County. The courts are very generous with that, and they'll let you do that. So you can punt the trust creation until later. I don't think it's the ideal situation, but it's better than not creating a trust at all.
Laura, we have a question.
Sure.
How do they pick between the three guardians selected?
The court will pick the order you put them in. The court presumes that you place them in the order that you wanted it to be. So this one, that one, this one. And now, so like if you have 3 children and you'd like them to be co-guardians, the court's not going to do that. They might do 2 of them, but 3 co-guardians is a lot. There's a lot of rules and regulations. We do a lot of co-guardianship as the children age. And so as your typical children, not the child with special needs. And what we'll see is like 2 siblings were the co-guardians, 1 sibling can't do it anymore. And so then, a niece or nephew or child your grandchild is chosen as the secondary guardianship so that there's continuity of guardianship, but they're going to go back to that document and look at the order that they were listed in. I don't know. The court would think to do that, but the family members should, if there's a dispute. Again, that list is when multiple people want to be guardian. You are not making somebody guardian when you write that down. You're telling the court who you would like it to be. And the court will take that under advisement, but obviously they still have to pass the background check. If they have a criminal conviction for elder abuse or abuse of child, they're not going to, any kind of criminal, they're not going to get to be the guardian. So and because obviously that might have happened after you wrote that document and you don't realize that's happened. And so the court's not going to, the court's still going to investigate your choices, your selection. One of the things that we recommend that people do when you're doing estate planning is you do something called a letter of intent. And a letter of intent is actually mainly like it's a roadmap. My child likes to sleep with the blue blanket. The red blanket is for naps. The blue blanket is for sleeping. At the end of the night, that if he doesn't or she doesn't have the blue blanket at the end of the night, they don't sleep as well, or they may not agree to sleep, until they get their blue blanket. Always wash the blue blanket first thing in the morning. That's what a letter of intent is, and it really is. It also can be, my child likes Disney, and my goal is that at least once every 2 years, that the money from the trust, as long as it lasts, will be that they get to go to Disney. For the record, that nobody has to actually honor that, but that knowing it helps everybody. It's not required. You can go on the internet and find sample forms for parents of children with disability of letter of intent. There are a lot of them out there, and they're kind of, family members have created them. And so if you actually put your child's disability in, you'll find ones that are sometimes earmarked for that disability. But it's really, like I said, it's a roadmap. And if you're doing a letter of intent, and if you're talking about a blue blanket and a red blanket and which one's favorite, you need to make sure you're coming back to this, because, usually those things change. And so you need to kind of update them every couple of years and realize what is new and what's not. But your wishes, hopefully it would be very similar, like what your goals and intent are. Like, like UC has a University of Cincinnati has a program to get list self-serve, the restaurant thing. I can't remember what it's called, and Safe Serve, and some other they have a program. And so if it's your goal, like you'd like the money used for them to go to that program and be enrolled at UC, that's great. If that's something that you wish for, then that's something you should write down in a letter of intent. We're going to come to this in a bit. The trustee of your trust can't be obligated to do that, but they want to know what you want to do, so they take that stuff into consideration. So we always recommend a letter of intent. All right, now we're going to talk about what trusts are. So trusts are documents. They become a legal entity, kind of like a corporation, but they have some flexibility. And I think people think of them as about for wealthy people. And that's not what it's about. And trusts were always about, oh, how to avoid estate tax. Well, there's no estate tax in Ohio, so nobody cares. And unless you and your spouse have more than 30 million, we don't care about federal taxes either. And since no one's jumping up and saying, well, I have 40 million, I'm going to presume nobody here has $30 million. So we don't need a trust to avoid probate. We don't need a trust to avoid the estate tax, but we do need a trust to provide money for your child with special needs where they get the benefit of that money, but it's not counted as a resource. So usually most of us are going to do what's called a revocable living trust. So the basic trust is if you came to me as a client and you were 28 years old and you just had your first child, and you're like, we need to do our estate planning. I'm like, okay. And you don't have a ton of money. You have some money, but not a ton of money. I'm going to say, let's do what's called a testamentary trust. And what that is like, we're just going to do your will. And in your will, it says, if my kids are still under 25 when I die, don't give them the money, put it in trust until they're 25. Why? Because the reality of it is, if you die soon, they're just going to have enough money to get through college anyway. There's not really going to be much left after that anyway. So who cares? And then we punt the decision on how to handle it, because we don't really know what you have when you just have one child who's 7 days old. They're just adorable and we don't know what's going on. But later on in life, when our kids are older and we have amassed a little bit more wealth, now we want what's called a revocable trust, a revocable living trust, where that says, hey, my kids don't get the money until they're 35. There's enough to pay for college, and I don't want my 22-year-old kid or my 25-year-old kid to be given $750,000. It's not going to end well. Everyone knows it's not going to end well. Either they think, woohoo, or they blow it. Either way, they blow it. Either they don't even go to work, or they just, it doesn't end well. There are also irrevocable trusts. As a general rule, these are done. Every trust becomes irrevocable when the grantor dies. When, if you make a trust, it becomes irrevocable upon your death. We also use them as a Medicaid planning technique, not for your children, but for you when we're concerned that you're going to go into a nursing home. Otherwise, they're not super popular. We don't see support trusts that much anymore. So let's talk about special needs trust. So a special needs trust nowadays, I always forget that last line. A special needs trust takes into consideration that the beneficiary gets federal or state benefits that are means tested, or alternatively, it takes into consideration that the beneficiary cannot handle money on their own. Maybe they actually aren't getting benefits, but if given a windfall, they would not fully comprehend it and wouldn't take good care of it. All right, so in a trust, the first step, even before we figure out this, is who's going to manage the money. You're going to be the trustee during your lifetime. But then what do? You got to pick somebody to do it. The more money in that trust, the more likely you want a professional trustee. All right. Now, professional trustees have to be paid, and that's true. And they're going to take about 2% of the value of the trust every year. Not the earnings, the value of the trust. So, but for the record, even if you name your typical child as the trustee, they get 2% too. They don't really have any expertise, but they're still going to get the exact. They can take the same amount of money as the banks and the professional trustees can take. So that's something to think about. The other thing I always like to point out is if you name your typical child as the trustee of your special needs trust, you need to remember two things. One, you're asking them to take on this job right as they have lost their parent, which can be very difficult for them also. And they're also now becoming the parent for their sibling. So it can be a lot overwhelming. The second thing you need to take into consideration is whatever money is not spent on your child with special needs, the typical child gets that money or their children get that money. That's what we call in the business a conflict of interest. And even though your child would never do that, they would never take from their sibling, you don't know who their spouse is going to be. You don't know what those kinds of pressures are going to be on the child, on your typical child, to maybe make decisions that you wouldn't have thought they would have made. But I would say this over and over again. They don't have the expertise to be the trustee of a special needs trust. And that's a generality because some of them do. But it's not just about investing money, it's about understanding when I can pay something and when I can't. And my example is swimming with the dolphins. If your child goes to Disney and they're paying for their Disney entrance fee and the hotel and the rental car and blah blah blah, and then they go swimming with the dolphins one day, and the trustee gets an invoice for swimming with the dolphins, they can pay that. But if the trustee gets an invoice for, and I've seen this, dolphin therapy, they can't pay that. If they pay that bill, therapy by definition is medical. And if they're paying medical expenses, then Medicaid can say, hey, if you're paying medical expenses, pay all these medical expenses. We're not going to pay their insurance anymore because you can pay that. And a very simple little oops can create huge repercussions in the trust. And that's why I'm not crazy about family members being trustees, because I think it can be overwhelming. So it's something to think about. So,
Laura, we have two questions. Can we,
sure.
you want to, so the first one, and you might be touching on this, I'm not sure in a future slide, but it says regarding divorced parents of a child with a special needs, do we need a will or a trust indicating, do we need a will or a trust indicating each other as the guardian?
No, because the parent of the child is always going to be the first choice. It doesn't matter what you said in your will, the other parent has the right. Unless a court has said they can't be around the child anymore. That wouldn't change anything. But the parent, the other natural parent of the child, is always going to have priority over anyone else. So,
And then there was a second question. If the guardian is not the sibling, but the sibling is the trustee, is that okay?
yeah, they don't have to be connected at all. Lots of times they aren't. So, especially you look at it like your child, your typical kid lives in Nebraska and doesn't really get back very often, but you have a family friend who's very involved in your child's life. And so they're acting as the guardian. But the typical child is a financial planner and very good at investing money. And so they're acting as the trustee and handling the money. Yeah. That happens. Again, it's great when you have people deep that you can pick people based on their skill set. So,
Great, thank you.
yeah. So again, so we're going through who should be the trustees. Obviously, you're the parent, you're the trustee until you pass away. We talked about the kids. Banks as trustees, you have to be very careful. There are a lot of banks that do focus. I don't know that they focus, but they have a lot of experience with being trustees of special needs trust. Fifth Third Bank stands out for that. Huntington is getting a lot of that. They're doing a lot with special needs right now. Northside Bank used to have a lot of experience with that, but smaller bank, they have turnover. I'm hearing feedback from clients that they're not that they're doing anything wrong, but that they just don't know the rules because it's newer people, and that's what you get when you get a small bank. I'm telling people to talk to Johnson Trust Company now because they have more stability. Like Fifth Third, they have more stability of staff, and I think that's important. Or you can go with a pooled trust. Pooled trusts are just like the other trust, except they're run by a nonprofit, and so they have all the money and they invest it. You're not going to get the rate of return on a pooled trust that you are going to get on a private trust. The other thing you have to be concerned about with a pooled trust is if I'm leaving the majority of my money to my child with the special needs, the majority of that money is coming from my IRA or my 401k. There are special exemptions that if it's being transferred to a qualified special needs trust, there are tax preferences that come from that. If the majority of my money that's going to fund my special needs child's trust is from an IRA and I put it in a pooled trust, they require I cash it out and then put the money in the trust, which is going to be a very large tax hit. And so your attorney should talk to you about what the options are given that. So you have to be something that I do a lot in my practice is we have your revocable living trust that we talked about that we use for everybody, regardless if you have special needs kids or not. And then we sometimes will do a private special needs trust, and that's where your 401k goes into. And then, because there's tax advantages to that. And then as the money is pulled out of the IRA, sometimes some of it goes into a pooled trust because the kids don't really know what they're doing. And so then they shift all that liability and knowledge to the pooled trust that charges a very small fee of just the amount of money that they pulled out of the IRA. So the point is it's not, there's a lot of parts moving and it depends on your situation. All right. So pooled trusts have a great purpose. So do banks as trustees. Personally, I do not like naming siblings. I don't really like naming that many relatives as trustee because they don't know what they're doing. And they don't know what they're doing. I have a brother with a disability, and I don't want to. I mean, I know what I'm doing, but my point is, we're close in age. Like, is this the smartest thing that I'm the trustee? Because as he's aging, I'm aging. Like, how does this? I'm not sure this really makes a lot of sense. Especially, I mean, my parents in their 80s, they're going strong. So, like by the time they pass away and this money comes, I'm going to be in my 60s or 70s. I don't want to deal with this. So I'm not sure it still makes a lot of sense, even when they have knowledge about this.
I do have another question, Laura, here.
Sure.
After the parents pass away, if the guardian does not manage the trust, how does the guardian work with the professional trustee or a pooled trust?
I need to make something very clear. Guardians have nothing to do with your trust. So when we talk, guardianship is another topic, but here's the thing. There's guardians of the person, and they're the ones who decide where your child lives and takes them to their doctor's appointments and makes all those decisions. And then there's guardians of the estate. That's not what we're talking about. So the trustee's job is to be aware of what your child needs. Within the trust, there's somebody else who's called a trust advisor, and that's where your kids come in and they say, "Hey, trustee, my brother or sister X, Y, and Z." So within the trust should be listing who is responsible for that. It has nothing to do with the guardianship. Guardianship is someone who's appointed by the court. And that is, in you're dead, you don't have any control over that. You can have said what you wanted, but you don't know who's going to become guardian. In your trust document, you should be laying out a lot of people. And for the record, we say in our trust documents, hey, by the way, the guardian is probably a good person to be a trust advisor. But, it kind of depends on your family situation, how deep the relatives are and things like that. So the guardian technically doesn't have any control over it because it's a special needs trust. Only the trustee can decide whether or not money comes out. So,
Thank you.
yeah. So if I'm leaving money, if I want to leave money to my child, I'm going to create a special needs trust. This is called a third party trust. Let's just keep that in the back of your mind. We're not really going to bring that up again, but sometimes you'll hear these referred to as third party trusts. But what we're really looking for is what's called a wholly discretionary trust. There is something called a supplemental services trust. No one does them anymore because upon death, a portion of the money has to go to Medicaid. But if in a wholly discretionary trust, upon the death of the beneficiary, none of the money has to go to Medicaid. So that's the trust we all use. All right, that's that one. Now, if I'm the person with the disability and I come into a large sum of money, I can either do a private Medicaid payback trust. Upon my death, all of the money has to go to pay back Medicaid up to what Medicaid has paid for me. I mean, if I've never actually gotten any money from Medicaid, there's no payback. But if there is any, they're going to get their money back. And I can either do a private Medicaid payback trust or I can join one of these pooled Medicaid payback trusts. As an attorney, I've seen private Medicaid payback trusts. I've never bothered to do them. I think they're cost prohibitive, and I just don't see the point. The pooled trusts tend to make more sense. If there was a lot of money and I wanted to invest a lot of money in very little Medicaid to date, maybe I would do a regular Medicaid payback trust because, again, I'd have more control in how it's invested, and I could earn more than a pooled Medicaid payback trust is going to earn. Pooled trusts are looking for low risk, not no risk, but lower than you and I would in our own investments. Because the pooled trust, their purpose is to make sure that money lasts the rest of the person's life. They're not worried about the next generation. They're worried about that individual. But so there are private Medicaid payback trusts. But in both of these, because I'm the person with a disability and I've come into money, under law, the only way I can transfer this money to these trusts is with the provision that Medicaid will be paid back whatever they're owed upon my death. So we want to focus on these wholly discretionary third-party trusts, right? It's a this is what you should be creating. And that's because now your child gets the money, right? But there's no payback. When they pass away, Medicaid gets nothing because it's never their money. It's always your money. And so they get the benefit of it, but they don't have it. It's never in their name, so Medicaid can't claw it back. So the thing about these is they have to be done right. And if they're not, they're very disastrous because then they are not special needs trusts. And then we have to take all the money and put them into one of those payback trusts. Most trusts say things like, hey, the purpose of this trust is to provide for the support, education, maintenance, welfare, housing, medical care, whatever. We say lots of things. That is a standard of care. Wholly discretionary trusts cannot have that because if I'm supposed to pay for the support, welfare, medical care of the person, why do they need Social Security and Medicaid? The trust money should be used for that. And that's why it can't say that. Wholly discretionary trusts also have to have something called a poison pill. And a poison pill is a clause somewhere in the document that says, hey, if Medicaid, if Job and Family Services determines that this trust is an available resource, normally what that would mean is the trust has to be terminated and all the money goes to the individual with the disability. And then they have to put it into a payback trust. But no, the poison pill says if Medicaid determines this trust is no good, then the trust gets terminated and it goes to the contingent or residual beneficiary, who is your typical children or your typical grandkids. And because it says that, Medicaid has no reason to terminate it. They'll work with you to fix it because who cares? I mean, they're not going to get the money anyway, so they don't care. You have time to go to the courts and fix the problem. So you need to have a poison pill. And old trusts don't have poison pills, and they have problems. And if you do all that, if you do those three things, then when the individual passes away, when the child with the special needs passes away, whatever's in that trust, nothing goes to Medicaid. Everything that's left goes to your other kids, your other relatives, the charity of your choice, whatever you want, but it doesn't go to Medicaid. And so that's why that's why when we talk about this wholly discretionary special needs trust or wholly discretionary third party trust, it's really important to understand that that's why we're pushing that, because now not only do you get to leave as much money as you want to your child with a special needs, but whatever they don't need, it's going to go to your other kids or your other heirs, and that's really ultimately what you want because it's your money. So um so these are what we have to think about. So the if I have a child who has special needs and they get a back award from Social Security, or they're in a car accident, and they get an award from that, or grandma leaves them $50,000, I can create a private Medicaid payback trust. The thing that has to be clear about this, it has to be created by some sort of family member who signs the documents. And when the child passes away, who's at that point probably an adult, then Medicaid gets paid back whatever they've paid out. The other thing you have to know about these is the individual has to be under the age of 65 when they're created. That's just a limitation on it. Now, if I do a pooled trust, then they can be over 65. There's some potential problems with that, but they still can do that, especially in Ohio. So in a pooled trust, the way it works is the trust has $1 million in trust, and then in your child's account is worth 50,000. And if I that was a horrible math equation. Let's do 500,000. So they have they have half of the trust, and so as the trust grows, their share grows, and if the trust lost money, they would lose money based on that same percentage. But of course, more people are coming in and people are pulling money out. And so the percentages shift of how much your child has, but that's what they all do. And then your child can create their own trust this way. But the other thing with pooled trust is when your child passes away, either the money goes to Medicaid, or most of the pooled trusts have a charity. So the big one in Ohio, they have their own charity, Arc of Ohio, some other places. They have the money. You can choose that the money goes to that charity, and so which is nice because if there's a connection for you with that charity, you can do that. The other advantage of these pooled trusts is they pick the trustee. You don't have to figure that out. You have to find a family member who's requesting the money out of it, but they have a trustee, and they come with all this knowledge about whether or not to pay money out or something like that.
There's a
All right, so
couple. Oh, I'm sorry,
yeah,
Laura. There's a
that's
couple questions.
I was just I was actually going to say, if you have questions about trust, now is the time because we're going to kind of move a little bit past them for a
Yeah,
minute.
I was looking at the slides. I thought, oh, I'm going to try to catch you here. So
Yeah.
we had a couple questions here, and I just wanted to make sure we hit them. You might have touched on them already, but I just want to read. The first question was, little confused. Won't the guardian need money from the trust to take care of the child? I think that's where the confusion between guardian and trustee came in.
Yeah, so guardians, I mean, I don't, they're different. Guardian doesn't mean one thing. Again, there's guardian of the person and guardian of the estate. You shouldn't need a guardian of the estate. No, if your child has a disability, the guardian has nothing to do with that. The county is providing them with the money to live someplace, right? They're providing them with housing options. I mean, it again, it sounds, I mean, I don't know what your goal is with the child, but the guardian has nothing to do with money. When we talk about guardianship in the disability world, we are generally talking about guardian of the person, and they're not that's you have a representative payee who deals with the Social Security money, you have a trustee who deals with the trust, you have SSA workers, and then you have if they live in a facility, the people who run the facility, their job is to oversee a lot of this also. But guardians really don't have anything to do with the money, and because generally your kid doesn't have any money, right? Their income is Social Security, so you name a representative payee like Lifespan. Their money is in a trust. Well, then the guardian doesn't have to do with the trust. There's a trustee who's dealing with that. And so no, guardians have almost nothing to do with money, because we don't ever. It's very rare that we ever have guardianship of the estate in Ohio for an individual with disability. It's usually just not necessary. So, and I I kind of get what you're asking, but that's not what they do. So it's you just have the point person, but still they're not going to be in charge of the money. And even if they were, the trustee isn't paying their housing expenses, so it doesn't have anything to do with anything. Because the one thing that these special needs trusts don't pay for is housing. They won't pay any housing expenses, so it's not relevant. They
The
might
next,
take
oh, go ahead. Sorry.
you can't you can take money from the trust and put it into a stable account, which is about what we're about to talk about. And then the stable account can pay for housing, but the trusts cannot. So
The next question was back when you were talking about Medicaid payback trust. It says, please explain the Medicaid payback trust once again. Does this have anything to do with the Medicaid waivers that were used during the entire life of the child?
yes, it has everything to do with those waivers. So when your child passes away and Medicaid says, "Hey, this is how much money we paid for your kid," and if it's an IO waiver, that could be $5 million. Your kid lives long enough. Could be larger. And then they say, in your Medicaid payback trust, there's $32,000. And they say, we'll take that 32,000 and apply it towards the $5 million we paid out. Nobody has to come up with the other $4.8 million. No one's looking for that. But they're just saying from that trust, they're going to take that money from there. Yeah, anything that Medicaid has paid, health insurance premiums, waivers, self IO, level one, all those, anything that Medicaid has paid out in their entire life, Medicaid will ask to be paid out of a special needs trust, a payback special needs trust, right? So again, if you leave money for your child, there is in a qualified wholly discretionary trust, there is no payback to Medicaid. Payback only occurs when your child has money in their own name that would make them ineligible for Medicaid. So we put that into a Medicaid payback trust. So it's really a very limited situation that comes up. It used to come up a lot more, but with stable, it doesn't come up. And for the record, stable no longer has a Medicaid. They don't have a Medicaid payback anymore. And that's actually a typo. And at the slide I'm looking at, there are two huge typos. Number one, the disability is prior to 46, and the last one is gone as of last week. That just went away. So I should delete that because it's gone.
There was one more question. If living or care arrangements determined by the guardian that need money from the special trust fund, how does the special needs trustee to ensure the child has better care when he is in the facility? Mm.
So to be clear, the special needs trust cannot provide for housing costs. But let's say this is an example I always have. So my grandfather had a stroke and he was in the nursing home. And then oddly, his brother-in-law also had a stroke. And so my grandmother just put him in the same nursing home room, right? A shared room. And then she hired this woman to come and sit with them for like 8 hours a day to make sure anything they need, she could run and take care of it. I mean, this is a long time ago and in the South, and it cost her like, $8 an hour to pay this woman. So if she'd had a special needs trust, the special needs trust could have paid for that caregiver, but the special needs trust could not have paid for the housing. That's not what they do. And again, the guardian, I think you're thinking this, I don't know who the guardian is. You think it's your other kid. My point is the guardian might not be your other kid. For a lot of reasons, they might not be your other kid. The guardian really might not be concerned about that. And the guardian's job might be, hey, they need to see the doctor. That's what the guardian really is usually. So the trustee should be determining that your child could have caregivers that would provide them extra care during the day, and then the trust can pay for that. But and again, that's what trust advisors are for. I think I don't like that. I wouldn't think. Stop saying guardian is what I'm going to say about that, because the guardian is a very narrow. It's one person and one person only, and it's a very narrow job. But lots of people could be the trust advisors. It could be anybody who's involved in your child's life and who could say, hey, they could really benefit from XYZ. Trustee, can we pay for this? And then the trustee will do the math and say, yeah, we can pay for that. That's a great idea. Or the trustee will say, that is crazy. We'll blow through all the money and it won't really provide much better of a lifestyle for them. So the guardian or the trust advisor or the family members who are in communication with the trustee, they're the ones who would say, this is what we think we need, but ultimately it's the trustee's decision.
I think that just answered the next question. I'm not sure if I'm going to read it anyway, just to be sure we're covered. I thought the trust can pay for the cost that it is not covered by the government fund, like the trip to Disney, fee to hire additional care to ensure my child has better care when he is in the facility.
Correct. Yes, that is correct. It can pay for all sorts of, yeah, you can pay for caregivers in addition to what's provided. It just, you can't pay for, you can't use the trust money to pay for things that the government's providing, but you absolutely can pay for supplemental things that are not covered. So, and if, it's if you want to have, it's the same thing. It's like, Medicaid will pay to have a tooth extracted, but you can use the trust to get a root canal. That's what the trust is for. So you would not use the trust money to pay for a tooth extraction because Medicaid will pay for that. But if you want the root canal, and let me tell you, on behalf of my aunt, should have gone for the root canal. If you're going to pay for the root canal, you can use the trust money for that. So you can always upgrade. That's kind of exactly what the trust is for. Is for upgrading.
Thank you.
So yeah, so we're going to talk about able accounts, which are stable accounts. Stable is the Ohio version of able accounts. If you're, I know some of you might not actually technically be in Ohio listening to this, but if you're a resident of Ohio, you're probably going to want to use stable accounts because you can get tax advantages for depositing money into a stable account. That's another conversation, another SALT talk coming up. Please watch that. But I want to have some brief stuff about this. So able accounts are like a 529 account in the sense that the money grows tax free. But you don't just have to use it for educational purposes. In fact, there's really no limit what you can use the money for. And I think it's $19,000 a year. I can't, might be 20,000 as of January, but you can basically put $20,000 a year into the stable account. Plus, if you're working, if you're the individual, not you, if the individual with the disability is working, they can put another 15,000, basically the poverty level in addition. So they can put, $25,000 a year. No, what am I saying? $35,000 a year into this account every year. Now, as of 2026, the disability is not 26, it's 45. It's actually prior to 46. So as long as they're disabled within their 45th year, they can contribute money to an ABLE account, which is important because that used to be a limitation. I mean, again, if you're in the DD world, that's not such a big deal. But if you had a car accident or something like that, this is a big deal that it's now gone up to 46. There are, in theory, a couple problems with ABLE. The one is that once your account balance gets to $100,000, you would no longer get your SSI payments of about $1,000 a month. You'd lose those. Now, if you drop below 100,000, you get your SSI back. And to be clear, if I have $100,000 in my ABLE account, I can just set up a Medicaid payback trust and move that money over there. And now I get my SSI again. But you need to remember something. The last line on here is wrong. As of this year, there's no longer a Medicaid payback. And as of last week, so it's weird because it says there's no payback, but if you died, the money had to go through probate, and Medicaid was taking the money through probate. But the Ohio Medicaid Estate Recovery said they would no longer do that for stable accounts. So as of last, there's no Medicaid payback on the money in a stable account. So I don't want to put it into a Medicaid payback trust. I want to leave it in my ABLE account, my stable account, but I can't let it go over $100,000. So, these are problems that do start to affect people. If you're in a position to put $20,000, $30,000 a year into this account, very quickly you could actually have $100,000 in here, and then you would risk losing SSI. What you guys also need to remember, though, is that when you retire or when you die, whichever is first, your child probably will no longer get SSI. They will get your retirement. And so if they're on your retirement, they don't lose that when they have $100,000 in the stable account. So that's something that's really interesting. The other thing that's so important about the able account or stable account is, remember I said I really cannot use this a special needs trust to pay for housing, but I absolutely can use a stable account for that. So if you have a trust for the benefit of your child, you can take $20,000 a year from the trust and put it into the stable account, and then that's money can be used to pay for housing expenses. So it's a form of money laundering. It's very legal money laundering, but it's money laundering, right? I'm just moving money between these different accounts to deal with this. And we see it a lot with parents who are still alive who want their kid to live independently in an apartment. And the apartment's rent is $1,500 a month. They only get $900 a month from Social Security. That's not enough. And so mom and dad put about $2,000 a month, a little less, about $1,800 a month into the stable account. And then they pay for the housing from the stable account. And that's allowed. But if mom and dad just wrote a check to the landlord for $1,800, then the child would lose their SSI, because that money would be treated as in-kind support and maintenance. There's a lot of things that I just said right there. But the point is if you need to supplement your child's life expenses, you need to be looking at a stable account, because by passing the money through the stable account, you're making sure they get to retain their entire SSI eligibility. I just need you to know that. And I need you to know that if you have a question about it, reach out to ABLE, reach out to your SSA at the county DD board. I just love to use little initials, or reach out to an attorney. You reach out to me, whatever. But you need to make sure that you've got that in your mind, that if you are using your money to supplement their lifestyle, that's fine. But you probably need to run it through a stable account to do that, because then their benefits are not negatively impacted. There's something called in-kind support and maintenance, where basically Medicaid and Social Security say, hey, listen, if you're giving them that much money all the time, then we don't need to support them. If you can support them like that, we don't need to. And so we won't. But if you take that same money and put it into a stable account, then they say, oh, okay, sure. It's weird. It doesn't make any sense, but it's really super helpful. So
There's two questions out here, Laura.
I'm surprised there's only two. Go ahead. Yes.
Yeah, there's probably more here because yeah, this is gets so where does the money go after you pass to who you list as a payable on death?
In a stable account, no. There's no payable on death. There's no named beneficiary in a stable account. You have to go to probate. And then it goes, if they don't have a will, it goes to their heirs at law, which if mom and dad are still alive, it's going to go to parents. Otherwise, it's going to go to siblings. I mean, I'm sorry. If they have children, it would go to their children. And then the parents, then the siblings, then the nieces and nephews, then the aunts and the cousins and stuff like that. So if you have a child who has a lot of money in a stable account, you might want to look at a will. Yeah, that was where the Medicaid payback used to catch us, but yeah.
The next question is, should there be something in the special needs trust specifically allowing funds transferred to a stable account?
There's no need. Any trustee who knows what they're doing. Again, to be clear, in a special needs trust, you can have no standard of care, so you can't require it. And there's a ruling that says you can transfer money. So any trustee should know what they're doing and be comfortable transferring the money. There have been cases, not necessarily with DD, but with people with mental health issues, where the head of the trustee of the special needs trust transferred a large sum of money into a stable account. Then the individual with mental health issues and a manic phase blew through all the money that was supposed to be their housing for the entire year. And that's a problem. That is my concern with stable accounts. You're alive. You can oversee your kid's stable account. When you die, whoever has the password has access to the money. So that's my I don't love it that much, but it's a good pass through entity. And now it's a good way to keep some up to 99,000 out of Medicaid's hands. But so, and for the record, remember I said you can take your money from asset from the stable account and put it into create a new Medicaid payback trust. For the record, I can take money from a Medicaid payback trust and transfer $20,000 a year into the stable account. And the minute I do that, there's no Medicaid payback anymore on that money. There's a lot of this is not, I don't want to say it's a shell game, but it's about paying attention to what's going on and transferring the money in a way that, gives you the best choices. But this idea about no Medicaid payback on the school account, that just happened this year. So we're just starting to play with that. But we are starting to play with it because it is something that we need to keep in mind. There's suddenly no payback on up to 100,000 now. And technically, if your kid's not getting SSI, they can have $400,000 in that stable account. I mean, again, they can only put 20 or 35,000 a year in if they're working. So it's going to take a while to get to 400,000. But if they're not on SSI, then there's no reason to not just be funding that stable account because there's no payback.
One more was just added in here. If my child lost his Medicaid, can he still keep his stable account?
Yeah, it has nothing to do with Medicaid. It has to do with you're attesting that they are disabled. And what does that mean? It's very questionable already. There's no real standard. Again, if I was in a car accident and suffered a traumatic brain injury, I'm disabled. If I have PTSD because I'm a veteran, I'm disabled. That's actually why they increased it to 46. If I have a mental health issue, that was always a big thing. Think how many people are mentally ill who don't get diagnosed until they're in their 30s. But it's a chemical imbalance they have their whole life. So the disability and Medicaid are not related. It has nothing to do with Medicaid. So it's just you're self-attesting that you are disabled when you set the account up.
Thank you.
Mm-hmm. Okay. So why don't we just use Ohio's Able account instead of a special needs trust? Well, because we can only put so much money into a stable account each year. And then, here's where I changed it to 45. There you go. Again, we lose SSI at 100,000. There was the Medicaid payback. I did not delete that. I'm sorry. And then you have a special needs trust. I can put money in any time. For these, the disability has to occur on or before age 45. So, a special needs trust, you can deposit however much money you need to at one time. And most people, when they die, they're leaving more than $20,000 to their kids. If you're like, well, we don't have a lot of money, when your house is sold, if that happens, that when they divvy it up, there's going to be more than 20. So that's the downside to stable. The other thing I'll say is what I kind of alluded to before. There's really no oversight with a stable account. It's an online account. Whoever has the password can start going on and ordering checks. They're given a debit card. I don't know. Now, the cool thing about it while you're alive is that debit card, you can set up the parameters that, your child can go to GameStop and spend $42 a week. They can go to Walgreens and spend $11 a day. And by the way, not just any Walgreens, you can say that particular Walgreens. And they'll send you a text every time the card is trying to be used. So it's a great tool if you're trying to teach your child money handling habits and things like that. It's a wonderful tool for that. And also if you're just trying to oversee things, it's great. But if there's nobody who's taking that kind of level of care, it can be problematic. And the reason I say things like that is because I've been doing this a long time. I've seen a lot of siblings take money from their siblings. I mean, a lot. I've seen parents take money from their children. That's not what we're talking about here because you're talking about leaving your money to them. But I've dealt with a lot of kids who had, a traumatic medical situation early in life, and they have a large, settlement from a lawsuit, and we have to protect them from their own parents who are constantly trying to get the money from the kid's trust. And we're like, it's for your kid. It's not for you. You want your own money. This is the kid's money. So, that's my concern with these stable accounts is if there is a bad actor, I don't really know what you can do to stop them because once you're gone, because I don't, there's not a ton of oversight on them. So that's where I get a little bit concerned by them. But um, the other thing that you should start talking about and thinking about is, and I'm sure this is something you've never thought about before, where's my child going to live when I pass away? What happens with the family home? Many of my clients want their child to live in the family home after they pass away. I I sometimes, and that's great. I sometimes think they're not really thinking about the fact that they have a very large home, and that they're cleaning it and they're doing the repairs, and the child with special needs is not going to be able to do those things. So that might not make the most sense, but it's oftentimes I think makes them feel the best. But if not the family home, is there another home? Or like, should we sell this house and buy a condo? Um, so this idea of what's happening with the family home is a big part of it. If you go to the Hamilton County DD website, they have a housing network, and they have tons of information about different living options. From them living in the family home to group homes to an apartment, what the pros and cons are. And, it's just, fun weekend reading. But it's something to keep in the back of your mind. We talked about guardianship. We talked about the fact that you now can have a guardian out of state, which is very nice. This idea of advanced directives, you can have them individuals sign powers of attorney, healthcare powers of attorney, and a living will. Those, they're generally the hospitals will take those. Sometimes the courts get annoyed with them, but nobody else seems to care. And then this idea of a do not resuscitate. So my aunt, who I talked about earlier, she had pancreatic cancer at the end of her life. And my mom was like, how do we get a do not resuscitate? And I'm like, you can't do that in Ohio. As a guardian, I can't go get approval from the court to do a do not resuscitate. I can just do it, but the court won't. The court won't do it. But in Iowa, where we're from, you actually go to the court and you say this is this healthcare situation, and the court says, okay, you can sign a DNR, and that's what we did with my aunt. And we decided not to do chemo for her at the end because it was crazy. She would never have understood what was happening. So, but you can have a conversation with your doctors about doing a DNR. DNRs are not something people sign. Like, I can't sign a DNR. I'm not sick. So I don't want to sign a DNR. I'm not sick. I might not be breathing because I'm choking on a gun ball, a gumdrop or something. You should try and resuscitate me. A DNR is something you sign later in life or when you've been diagnosed with something or you're under care for something that has this as a consequence. It's not a standing order that we see signed. Instead, again, they can sign a living will or a healthcare power of attorney that gives them that. In Southern Ohio, there's something called Planned Lifetime Assistant Network. There's Plan of Southwest Ohio is a nonprofit that will work with families to provide for your child after you're no longer there. They are not a Medicaid organization, which means you would hire them to do that. But they will oversee that the SSA, that the county DD board is providing for your child. They'll go, if you want them to, that's what you do, they'll take them to their doctor's appointments. They'll make sure they'll come in and do spot checks. And just like you would do, that's what they do. It's an organization that I think you should have in the back of your mind. They also do like craft days and things like that, where there's some social aspects to it that a lot of families find very helpful and something to think about. one of the things we have when we talk about guardianship is who can we do that? Who would be willing to be guardian, especially if you don't have other kids, and so or your kids are very far away, and so building that network is so important. And plan is something that can help you build that network. So it doesn't work for everybody, but a lot of people do. For the record, I always like to point out I'm on the board. I like plan. When we moved to Cincinnati, when my parents and my brother moved to Cincinnati, I was like, "You're going to plan events because I'm not. You're not. I'm not changing my whole social life when mom and dad pass away." And which was good. It was a good choice because he met a lot of people through that. Moving to a new town when he was in his 40s, so that was important. Okay, so now I'm going to hang around and answer questions. But if you need to reach out to me, this is my email and the phone number. Give me some time to respond to an email. I'm happy to answer questions if they're quick and all that stuff. If they get a little too specific, that's fine. I'll just tell you, it's too specific. But so I've been working in this field, I mean, really all my life, and truly. And to me, I think it's really important. It's a very important concept to me. And so I've always said I want to be a resource for you, for everyone who's dealing with this. It's important to me. So I am happy as a general rule to answer questions. And if you email me and I haven't responded in 72 hours, you should email me again. So, because sometimes, especially right around this, at certain times of the year, I get really, really busy. So, but this is my last week of busy. So, starting next week, I should be much more attentive to people. So, but feel free to reach out if you have questions. And I'm going to stay here for a while and I'm going to answer questions now if you have more questions to ask about this. So, I have to figure out how to make.
Laura, I'm going
Good.
to go ahead. I'm going to go ahead and stop the recording. And then so we can get into the questions. But I want to thank you again for presenting. And we'll have a link in the chat box for the presentation. So 1 second while I stop the recording. 1 second. It is, why is it not? There we go.